Let's get reaction now on the back of that judgment, and to give us that analysis this evening, we are joined by the former Constitutional Court Justice Johann Kriegler. Justice Kriegler, good evening to you, and thank you very much for your time.
Good evening. Thanks for inviting me.
The interpretation of Section 47(1)(e) of the Constitution is what was in contention here. How important was it that the Constitutional Court lays it bare as to what it is?
Clearly, that was important. Section 47(1)(e) is important, but the judgment is much more important than that, because it establishes two things that were possibly in doubt. One is that the Constitution recognizes that the IEC is in charge of the election, and the IEC was fully entitled to take the decision that it took with regard to the candidacy of Mr. Zuma. That was challenged. That's important that the court has now said the IEC is authorized to take those decisions.
Yeah.
The second important thing is that the IEC was right. The Constitutional Court has held that it was correct in its judgment, and it has set aside the judgment of the Electoral Court. That's very, very important. It underscores the competence and the authority of the body that is managing our elections.
Indeed, and I want us to get to the IEC, but we'll do that a little later, because I want us to deal with what the confusion would have been really stemming from the Electoral Court, because it had to do with this particular sentence of 15 months, which was not appealable.
Yes.
What exactly about that judgment would have confused the Electoral Court judges?
Quite frankly, I did not understand the Electoral Court judges. I didn't understand either of the two main and the third judgment. I didn't understand their reasoning. It seemed to me perfectly clear, as the Constitutional Court has made clear. The Constitution says in simple, straightforward English that everybody who's entitled to vote is entitled to stand for office, except 1E. If you have been convicted of an offense and been sentenced to more than a year in prison. That's what the Constitution says.
Yeah.
Straightforward, simple. There's a proviso to it, which is irrelevant in this case. It says that disqualification doesn't kick in until you have exhausted your remedies.
Yeah.
If you had an appeal, if you had appealed and it had been dismissed. To me, it was straightforward from the beginning.
Now that this confusion has been cleared, do you think that the Electoral Court, its standing, might come up for questioning, or you think that this was a genuine mistake on their part or misreading of Section 47(1)(e) of the Constitution, and it was well worth finding out from the highest court in the land as to
I think it was well worth taking that on appeal. The Electoral Court has got a very, very difficult task, and it's very, very easy to be wise after the event. They were wrong. They were wrong because they had to make a series of unprecedented decisions in a hurry.
Yeah.
And neither of those is good for judges. We like precedent. We like to go to what has been decided before. None of this had been decided before, and it was get on with it, move, because there's an election around the corner, and that's not good for judges either. They don't like to be in a hurry. They like to think and reflect. So I don't want to be overcritical of the Electoral Court in this instance.
Yeah.
It was wrong. It was in good faith. It made a mistake. It has now been corrected. Pelil Indaba.
Let's then talk about the IEC and the important work that lies ahead for them. This was one matter that clearly gave them sleepless nights. The chairperson was here ahead of this particular hearing at the Constitutional Court, making it very clear that all we want is to seek clarity. It's got nothing to do with former President Jacob Zuma's standing as a candidate of parliament, but more to do with the interpretation of this particular section. How good a job have they done here by taking this matter to the Constitutional Court?
I'm partial towards the Electoral Commission for historical reasons.
Yes.
I'm putting that aside. I think they are doing a sterling job. I am proud to have been associated with that body whom they now head. I think that they have headed a number of very serious difficulties. They've done it with a cool head and a firm judgment. They have, I think, impressed any experts who've been watching them. I think they've done an excellent job.
It's up to you which hat you choose to wear here, either that of a Constitutional Court Justice or indeed that of a former head of the IEC. The Kathrada Foundation wanted to be friends of the court, and indeed I think they got that. Coming out of this judgment today, they are clear that the former president should never have been in contention in the first place, given his stance on the Constitution. What do you make of those statements?
I read what Mr. Zuma is reported to have said over the weekend. I regret that a former president has said that, if indeed it is what he has said, about the judiciary, about his trust in the judiciary. I have heard what he has said about, reported to have said about the Constitution. I regret that a former head of state who's taken an oath of office to uphold our Constitution should be saying things like that. I disagree with him. I don't think he should be saying them. I don't think it is proper for a former president to be attacking both the legitimacy of our Constitution and the legitimacy of our judiciary. It's unworthy of the man.
Sure. Justice Johann Kriegler, let me thank you very much for your time and indeed the analysis of what has happened today.